In today's edition, we are going to treat the language used in court, the terminologies used in court. It is not necessary that you come to court with your lawyer and you don't understand the language that they are using in court. It is not necessary that you are taken to court and you don't know what they are saying until your lawyer just tap you or wave you that you should come out so that they should go. So that is why this lecture today is very, very necessary for everyone. Everyone, because you don't know what will happen tomorrow. You don't know when you'll be taken to court, or you don't know when you take somebody to court. So stay connected as we are going to take you through the terminology used in court. First of all, I am going to take the first one, which is the plaintiff or claimant. When you hear the word plaintiff or claimant, or they say the plaintiff is in court or the claimant is in court, it means that the person who initiates the suit before the court, the person who bring the case to court, especially in a civil matter, is called plaintiff or claimant. So plaintiff and claimant is synonymous, is the same word. You can either refer to the person that initiates the suit, the person that brought the case to court, as plaintiff or claimant in a civil matter. Now, the person that they brought to court in a civil matter is defendant. So, the person that the plaintiff institute the suit against, the person that the plaintiff sue, is called the defendant. So the defendant is the person whom the suit is initiated against, that the claimant or the plaintiff is asking the court to do something for him. And that thing that the plaintiff is seeking the court to do for him is what they call relief. They call it relief sought. You understand? So relief sought is a request or demand or prayer that the plaintiff is asking the court to do for him. You understand? So that is the relief sought. So I have explained three things now. I have explained what is called plaintiff or claimant, the person who institutes or initiates the suit before the court. Defendant is the person whom the plaintiff institutes the suit against, while relief sought is what the plaintiff or the claimant is asking the court to do for him. So you understand? So when you come to court and you are hearing plaintiff, defendant, claimant, and relief sought, you should be able to understand what they are saying, especially in a civil suit. Then, if it is criminal matter, you hear something like complainant, defendant, or an accused person. So, the complainant is a person who reports a crime to the police or who makes the complaint to the court directly without reporting to the police. You understand? So, complainant is the person who reports a crime to the police before the police will investigate and file a suit in court. But if you don't report to the police and you file your complaint in court directly, you are the complainant because you are the one that makes a complaint of a crime to the court. So in that situation, the person you complain the crime against in court is also called the defendant, because he's coming to defend himself, or it can also be referred to as an accused person, because we are accusing him that he committed a crime. So the person who made a crime report is called the complainant, and the person whom the crime report is made against is the defendant. So another word that we're going to look into is arraignment. Arraignment. Arraignment is the process of bringing an accused or the defendant before the court to hear the charge or to hear the complaint against him, to enable him take his plea, to enable him react to the charge against him. That's what is called an arraignment. The process of bringing an accused person to court to enable him hear the charge or the complaint against him, to enable him take his plea, is what is called arraignment. So another word that you hear in criminal case in court is surety. A person who will attest to the fact that you will make yourself present in court throughout the trial. It is the person that will assure the court, will give assurance to the court that you, as a defendant or as an accused person, will make yourself present in court to stand for your trial throughout the proceeding before the court. That is the surety. Then another word that you hear is a proof of evidence. Sometimes you'll be accused of a criminal case and you come to court. You come to court with your lawyer on the date of hearing. He rose up and informed the court that he has not been served with a proof of evidence. So the proof of evidence are those documents or material that the prosecutor, that is the lawyer of the complainant. The prosecutor is the lawyer to the complainant. So if you hear the prosecutor counsel, they are talking about the lawyer to the complainant in court. So duty of the prosecutor to make the proof of evidence available to the defense counsel, that is to your own lawyer as a defendant. So the proof of evidence are those things that the prosecutor would want to rely on in evidence in proving the case against you. The law is that whatever that the prosecutor want to rely on to say that you actually committed the offense is what they call proof of evidence. And the law is that those things that you want to rely upon in evidence, you must make those things available to you or to your lawyer before you've been able to tender it in court. And if you hear tendering, it means the thing that they want to present to the court to show as evidence. Whereas so it's trying to tender, it's trying to present it to the court. Are you following? So those things that the prosecutor or the prosecuting counsel want to tender in evidence to prove their case against you is what they call proof of evidence. So in case you now hear proof of evidence in court, it's talking about those things that the prosecuting counsel want to rely on. It might be the statement you have made in the police station. It might be the picture that has been taken. It might be the record of conversation. It might even be the cutlass that maybe was used. If it is murder case, maybe the cutlass that was used in killing the deceased. And maybe if it is armed robbery, it might be the gun that the accused person is suspected to have been used in robbery. So anything that they want to rely upon in court to show that you actually committed that offense is what is called proof of evidence. And as I said earlier, the law is that anything you want to rely upon as your evidence before the court to establish the case against the defendant, you must make a copy of that document, and that document must be served on the defendant or on the accused person. So that is why proof of evidence is necessary to be served on you as a defendant before the hearing of the case, before the court will go into trial. So another thing that we hear is conviction, especially in criminal matter. Conviction. Conviction simply means when an accused person or a defendant is found guilty. Then, if the defendant or an accused person is not found guilty, it means that he has been what? Acquitted, or it is called acquittal. Acquittal means when the defendant or an accused person is not found guilty. And another thing that you hear in the criminal matter is what? Sentence. Sentence. It's not the sentence that you know in English language, but sentence in law. And sentence in law means the punishment given to a person who has been convicted is what is meant by what? Sentence in law. So the prominent one that you'll be hearing every day when you come to court is what? Adjournment. Adjournment simply means taking another date for the continuation of the hearing of the case before the court is what is called adjournment. Taking another date for the hearing or for the continuation of the proceeding of a court is what is called adjournment. Thank you for being here with us on Court TV. I still remain your host, Triple A, on Court TV. Please endeavor to share, to like, and also to subscribe to our platform so that will enable us to do more.
Court TV. Explore the entertainment.